I thank the gentleman, and it does sort of put a fine point on this. Some have made reference to the January 6th mob and the handful of officers that suffered, or that one in particular who I know committed suicide subsequently. I've got in front of me articles from Minnesota journals who say that that there's just a massive increase in disability retirement based on applications based on PTSD in Minnesota. In fact, the number of Minnesota police officers and firefighters applying for disability retirement tripled in the past fiscal year. That's 3 times, and we're seeing a tremendous amount of this. And I don't think we have any choice, frankly, but to support the amendment being offered. But it is a massive expansion of the program. And in fact, what is most interesting about it from the point of view of sort of the workers' compensation system typical regime is this expansion has a couple layers of presumptions of compensability. Usually there's a requirement for any kind of condition that is compensated under a workers' compensation type program to have a showing that the condition and the consequence were in the course and scope of employment. It was, that has to be proved by the claimant. Here, if there's
would the gentleman yield?
Yeah, and I'll yield back. Let me
just for 1 second. What you just said is exactly what's contained in this bill.
Yes, sir. Well, no, they're presumed compensable here. They're very, and it's going to be a tremendous potential financial impact. I think we have to do it because I think a lot of this flows from the advocacy of defunding police and the disorder that's resulted and all the violence that's resulted from that. But it is an enormous cost for citizens to bear, and I think Mr. Buck's question is correct, and we ought to have some discussion about how expansive this change is to the pre-existing program, which was limited previously to officers killed in the line of duty, state and federal, and more recently a disability, total and permanent disability resulting from such a catastrophic physical injury, going out to PTSD and ASD from disturbing events, and then presuming the compensability thereof without showing that without proof that it resulted from a triggering event in law enforcement activity, or that the disability resulted from the PTSD. Both of those are presumed.
Gentleman yield?
Yes, I yield back to Mr. Buck.
It does say that it says it relies on a presumption. If you look at page 7, starting at line 7, a public safety officer shall be presumed to have died or become permanently and totally disabled within the meaning of subsection A or B as a direct and proximate result of a personal injury sustained in the line of duty.
Yes, Mr. Chairman. The point is they are being presumed. They are not being shown to have been the direct and proximate result. They don't have to prove that for their claim, which is the basic workers' compensation approach. It is now presumed that they are compensable. And in order not to fund the claim, the authority, the board has to prove by clear and convincing evidence that it was not connected.
What's a bigger deal?
Would the gentleman yield just to a point on that real quickly?
By all means.
Aren't you engaged in rank speculation?
Just as you were, just as the members, and I started by saying it was rank speculation because there were members on that side saying we don't care about the leak. Then I say you don't care about the leak.
Well, I mean, you're talking about the source of the leak. Are Republicans
the only people allowed to invent facts? I mean, my God.
Well, I guess what I'm asking, sir, is you're speculating about the source of the leak on the court. I mean, you're talking about protecting our democracy.
Just as the members on that side.
I'm sorry, I did not speculate in public.
Well, let's take it back.
I do, Mr. Chairman.
Move to strike. Purposes, Mr. Bishop, seek recognition.
Move to strike the last word, Mr. Chairman.
Is recognized.
Thank you, Mr. Chairman, and not to put too fine a point on it, but just to make sure, and again, support the bill. I think we have to, but there is a side to this that's troubling in terms of the expansiveness of the financial obligation undertaken and maybe a moral hazard. That is to say, what we may be creating and have created some about the politics of some that have facilitated or given license to a far more disorderly environment on our streets that's seeing a rise in crime. We've talked about that before. 30% increase in homicides. It's part of the same phenomenon. And I'm going to ask unanimous consent at the end to submit a couple of articles that I've got in front of me, but one from the Minneapolis Star-Tribune from April 2 begins this way. Hundreds of police officers in Minnesota diagnosed with post-traumatic stress disorder have severed ties with their department in the last 2 years, resulting in millions of dollars in payouts through workers' compensation settlements and state disability pensions. The issue is most acute in Minneapolis, where the city has paid out more than $22 million in workers' comp to about 130 officers for PTSD-related claims since the police murder of George Floyd in 2020, according to a Star-Tribune review of City Council minutes. The bill that we have before us, to the point about the presumptions, if someone has a diagnosed condition of PTSD, any suicide that occurs or any alleged total and permanent disability, both are presumed to result from the PTSD. But if they have a PTSD condition that is not diagnosed, for which they've reached out to an employee assistance program or sought help from or treatment or diagnosis, so if they've communicated to anybody thinking they may have PTSD, whatever they claim to suffer is going to be presumed covered here. Consider the fact that we've seen a wave of police force retirements under the conditions that law enforcement officers are now required to face. Recognize that if you have a presumed, and in fact this article goes on that I was making reference to, talking about the fact that this system would be susceptible to claims that are not well grounded very readily. And so that we're unfortunately there's a creation of a problem to which we must respond for the legitimate claims that are multiplying. But there also is an open-ended expansion that will extend to claims that are not particularly legitimate, cannot be legitimate or well contested, that may result really from the conditions that law enforcement officers are placed under, to have nothing to do with a stress-causing or PTSD-causing event, but the fact that they're systematically not respected and not protected in carrying out their duties. So we are going to see it. It's going to be a massive yawning liability now for the federal government on top of the state and local exposures that you're seeing in these articles. So I'd finish by asking for unanimous consent, Mr. Chairman, to submit the article I referred to from the Minneapolis Star-Tribune, as well as, bear with me just 1 second, as well as another article from the Minnesota Reformer on the same subject matter titled Cities Save Police, PTSD Disability Claims Are Fiscally Unsustainable, dated August 17, 2021.
Chair, with that, I yield to, yes, Mr. Bishop.
Thank you. Thank you. One point to be made along the same lines about the very bill before us is that the final section provides that in the event it is a change in practice for recusal, extending to the United States Supreme Court, not only to lower courts, but that it allows then a party to bring a recusal motion against one of the sitting justices, and then to allow that to be decided not by the justice, but by the full court. Consider what the change in the balance and how power is distributed on the Supreme Court would be as a result of that. Assume there's a moderate wing of the court and a conservative and a liberal wing. It would then give rise to new power struggles on the court if it were followed for a member of a moderate faction to take out of power, to prevent from participating, either one of the judges on the left or on the right, in a way that the Constitution doesn't envision, and would be imposed by this legislation. I mean, that's just one example. I'm going to come back with more, but this legislation is unwise. Thank you.
Will the gentleman yield?
Time of the gentleman has expired. For what purpose does the gentleman from Tennessee seek recognition?
Strike the last word. Am I recognized, Mr. Chairman? Oh, she's reading. I'm sorry.
Amendment to the amendment in the nature of a substitute to H.R. 76.
Without objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Mr. Chairman, early in the markup, in response, I think, to Mr. Jordan's comments or someone's, the chairman made the point that you had said in the opening that, and I don't remember precisely the words, that that the leak of the draft opinion from the Supreme Court in an unprecedented exposure of its internal deliberations was a matter of considerable concern. And I appreciate that sentiment, although there's been obviously a grave division here in the discussion or the debate today so far on the bill. But given that acknowledgement, this amendment would seek to do something about it. That is, what is before the body is a bill to require an ethics code and so forth at the Supreme Court. I've spoken to one part that I think is gravely concerning, the notion that the Supreme Court will decide recusal motions as a whole. I think that would be ill-advised. But this amendment does something very simple. It says that in addition to the provisions already there about establishing rules concerning the disclosure of gifts, travel, and so forth, that the rules will also govern the disclosure of non-public court documents, including draft opinions and other court documents reflecting the confidential deliberations of the court by any justice and any law clerk to a justice, and will provide procedures to address and prevent the unauthorized disclosure of non-public court documents. So we have, by virtue of this unprecedented attack on the court as an institution, which is what that represents, and I have heard some members here today on the other side of the aisle have suggested they not concerned about that attack. We should all be concerned about it, and it is certainly of equal moment to the notion brought up as it is and under the timing that it is, that this body ought to be attempting, perhaps in conflict with the Constitution, to establish an ethical code for the court. So at the very least, if we're doing that, let's require, to the extent of our ability, the court also to take steps so that these attacks, now that they've been sprung, now that they are in vogue, they be acted upon and prevented in the future. And I wonder if anybody wants, well, I guess before I yield back, given the availability of time.
I will, if the gentleman will yield.
Well, let me take the time myself, because I wanted to put a finer point or further extend the comments of Mr. Roy about what the rhetoric has been on this notion that over and over again the Supreme Court justices lied, somebody said, engaged in deceit, and so forth. That's simply not true. And to the point about much of what is going on here, when it is understood, I mean, the folks who've made the accusation understand what is meant in the confirmation proceedings when justices talk about what is settled law. It means that the principle of stare decisis applies, that the court has to follow principles but it's always subject to reevaluation under the doctrine of stare decisis. And there's never been any misleading about that. But, just to recount everybody on this body, this committee of the House of Representatives on the Judiciary, Mr. Jones said that the justices deceived their way onto the court, 4 justices, because they acknowledged Roe as precedent. Mr. Liu said that 4 justices made misleading statements in their confirmation. Ms. Jackson Lee said they breached the confirmation process. She said, she gave the example, she said Brown versus Board of Education is settled law, but Brown overturned settled law. Plessy versus Ferguson. Mr. Cohen said they lied. I mean, Mr. Roy has been through it about what it means, but everybody knows it. That's the problem. So when we're talking about what we're engaged in here, we're following one week after an attack on the United States Supreme Court as an institution by the leak from its deliberations. This body has multiple members attacking the Supreme Court by purporting to characterize as deceitful conduct and lies and so forth something that is entirely understood and understandable and established in the law. That is what the principle of stare decisis is, and when and under what circumstances
Time of the gentleman.
precedents are subject to reconsideration.
Time of the gentleman has expired.
I thank the gentleman from Ohio. There's another distinction. Absolutely, there's a difference between criticizing in a Supreme Court opinion or a justice who has written one after it is done and before it occurs in an attempt to intimidate. That's an important distinction, but it's not the only one that's at play here. It's perfectly fine to criticize decisions of the court and judges, but what we're talking about are attacks on the institution of the court as a response to a decision you do not like.
Well said.
So it is that when you do not like a decision or you do not like how the court has become composed by the processes, you speak, as one of our members did today, of justices being accomplices to political figures. You speak of justices, go back and say justices, sitting justices are credibly accused of sexual misconduct. They've been confirmed, they're on the court, they're not been impeached, but you seek to delegitimize them. You say that, you use this notion about justices having deceived or lied their way onto the court. That's an attack on the legitimacy of the court itself, and it's a smear because it's not true, and everybody understands who's making the accusation that it's not true. Packing the court is an attack on the institution of the court.
Yep.
That is what that is. I understand. Look, back in the day when Dred Scott was overturned, Democrats didn't like that decision. And when Brown versus Board of Education overturned Plessy, Democrats didn't like that decision. Criticize it if you want. But even those Democrats didn't go and try to undermine the institution, the essential institution of our constitutional system, the court itself. Mm-hmm. That is what is going on here today. That is what this hearing and its timing and its purpose goes hand in hand with the attack last week on the deliberative process of the court. Yep. By undertaking, as comment after comment after comment on the majority side has indicated, an attack on the institution itself, delegitimizing it, attempting to delegitimize it. I would love to hear on the majority side someone take on the impeccable logic of that draft opinion that has leaked. I haven't heard one member do that.
Will the gentleman yield?
On the 3 seconds I have left, I'd be glad to.
Time of the gentleman has expired.
Good job, Dan.
For what purpose does Ms. Jackson-Lee seek recognition?
To strike the last word.